Today we're going to go over a recent court case that appeared in the United States Court of Federal Claims. It is case number 22-721C, filed on July 21st, 2022. The plaintiff is Marcel James LAMAR Wood versus the United States. Mr. Wood decided that he was going to forego any legal help. He went in as a pro se plaintiff, and the case was dismissed for lack of jurisdiction and sovereign citizen allegations. Now, before I start, I want to make it clear that the simple fact that it was dismissed for lack of jurisdiction, I'm not necessarily worried about that, because of the fact that this kind of stuff hasn't been brought up to any court that does seem to have jurisdiction over the matter. And when it is brought up in court, it's summarily dismissed every time. So if you have an example of a court where the court had jurisdiction and this type of argument was brought to that court, then please, by all means, in the comment section, drop the case, so that way we can go ahead and review the case and take a look at things. But for now, this is just another example of the court's opinion in terms of the information being relayed within the movement, because I can't just say that it's Christopher Hauser's group that's doing this or Christopher Hauser's group that is teaching this information. And I would also like to make it clear for the people out there that are delusional that everything that this gentleman says in this court case can be readily found throughout the movement. So, for those of you that will come and say, well, he didn't say this or he said that, and we don't think that, that's not true at all. Everything that is in this case, you can go inside any one of these movements, any one of the groups, and you will find the same information verbatim. So let's get into the case. Opinion and order. Sweeney, Senior Judge. Pro se plaintiff Marcel James LAMAR Wood seeks declaratory and unspecified monetary relief arising from the United States' purported misappropriation of his estate. For the reasons discussed below, the legal fiction underlying plaintiff's claim is insufficient to establish jurisdiction in this court. Therefore, the court dismisses plaintiff's complaint. Background. On June 28, 2022, plaintiff filed a form complaint accompanied by an appendix of documents. In the complaint, plaintiff alleges that the United States was and is acting as the custodian of his estate because, pursuant to the Sestake v. Act of 1666, it presumed that he was dead or had abandoned his estate. He further alleges that neither presumption is accurate. He is alive and has not abandoned his estate. He represents that to support his allegations, he attached to his complaint evidence of the United States' involvement over the said estate and the name and registration number of the estate. Finally, without any further explanation of the nature of his claim or the jurisdictional basis for asserting his claim in this court, he requests a declaration that he is the entitlement holder of the estate, a declaration that he is alive, and to be compensated the interest of the estate from the United States. Turning to the complaint's appendix, some of the documents appear to set forth a philosophical foundation for plaintiff's claim, while others are in the form of estate planning documents apparently intended to support his claim. The court will not examine each of these documents in detail here, but instead provides a brief overview of their contents. The first document is titled Notice of Warning to Utility Companies. The key allegation in this document is a reference to the bankruptcy of the United States that purportedly occurred in 1933. Since House Joint Resolution 192, HJR 192, Public Law 7310, was passed in 1933, we have only had debt because all property and gold were seized by the government as collateral in the bankruptcy of the United States. The document also includes the following passage, presented without alteration. Every judge and every attorney in America, especially those who hold positions with several direct connections into the utilities company's bank accounts and acting as attorneys for the banks, most presumably in all other countries as well, since they all get their instructions from England, the same place that all banks get their instructions through the comptroller of the currency, headquarters in London, England, each knowing the above and incorporated to be true, since they are all well versed on the U.S. bankruptcy of 1933 and that America still remains to date in a state of emergency and operates under English law, though that also is supposed to be a well-kept secret. This means there is no money. It further means that since there is no money, American signatures are used as the credit to run this country. That in turn means that it is the American people whom are the creditors, not the debtors, as the banks and utility companies would like everyone to believe. The second document is a schedule of fees through which plaintiff purports to establish specific monetary penalties for various infractions related to the trust which owns the copyright, trademark, and trade name Marcel James Lamar Wood, trademark. For example, the unsolicited interrogation of the trustee of the trust as to that person's name or driver's license number is a $10,000 infraction. Requiring a signature under threat, duress, or coercion is a $1 million infraction. The third document is a first will and testament of the grantor in which plaintiff purports to provide identifying information for the estate that is the basis for his claim. I, Sheila Van Doria Mack, being of sound mind and over the age of 50, as grantor of the private trust security, estate Marcel James Lamar Wood, registration number 1989-005198, date of registration July 13th, 1989, do bless and do grant irrevocable power of attorney over said trust security to my son, Marcel J. L. Wood, his agents and or assigns this 20th day of May 2022. In the next document, an affidavit of correction, plaintiff asserts that he is correcting an error on his birth certificate because the name of the birth certificate is in all capital letters, which must be considered a fictitious name, whereas the proper form should be written Marcel James Lamar Wood. The next two documents are affidavits, one of knowledge of facts and another of life, which appear to have the purpose of establishing, respectively, the truth of the assertions in the documents attached to the complaint and that plaintiff is indeed alive. In the document that follows, plaintiff references the Sestake v. Act of 1666 and includes a passage attributed to this authority related to the circumstance of a person being alive after having been presumed dead. Plaintiff then presents a declaration of trust, in which he identifies Marcel James Lamar Wood, registration number 1989-005198, as a component of the trust corpus. The final document is a last will and testament of Marcel James Lamar Wood. Having considered all of plaintiff's submissions and finding a response from defendant unnecessary, the court is prepared to adjudicate plaintiff's claim. Discussion. Although the legal theory presented in support of plaintiff's claim is cryptic, the complaint has all the hallmarks of a sovereign citizen suit. As is common in these suits, plaintiff relies on a legal fiction to support a monetary claim that has no basis in the laws of the United States. Before explaining further, the court addresses the governing standards of review. A. Standards of review. 1. Pro se plaintiffs. Pro se pleadings are held to less stringent standards than formal pleadings drafted by lawyers and are to be liberally construed. Erickson v. Pardis, 551 U.S. 8994, 2007, per curiam. Quoting Estelle v. Gamble, 429 U.S. 97, 106, 1976. However, the leniency afforded to a pro se litigant with respect to mere formalities does not relieve the burden to meet jurisdictional requirements. Mineham v. United States, 75 Fed CL 249, 253, 2007. Accord Henke v. United States, 60 F3D 795, 799. Fed Circ. 1995. The fact that the plaintiff acted pro se in the drafting of his complaint may explain its ambiguities, but it does not excuse its failures, if such there be. In other words, a pro se plaintiff is not excused from his burden of proving, by a preponderance of evidence, that the court possesses jurisdiction. See Banks v. United States, 741 F3D 1268, 1277, Fed Circ. 2014, citing Reynolds v. Army and Air Force Exchange Service 846 F 2D 746, 748, Fed Circ. 1988. Number 2. Jurisdiction. Whether the court has subject matter jurisdiction to decide the merits of a case is a threshold matter. See Steel Company v. Citizens for a Better Environment, 523 U.S. 83, 94-95, 1998. Without jurisdiction, the court cannot proceed at all in any cause. Jurisdiction is power to declare the law, and when it ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. Ex parte McCardle, 74 U.S. 7 Wall, 506, 514, 1868. The question of subject matter jurisdiction may be raised by a court on its own initiative at any stage in the litigation. Arbaugh v. Y&H Corp., 546 U.S. 500, 506, 2006. Accord Fulden v. United States, 379 F3D 1344, 1354, Fed Circ. 2004. The ability of the United States Court of Federal Claims to entertain suits against the United States is limited. The United States, as sovereign, is immune from suit save as it consents to be sued. United States v. Sherwood, 312 U.S. 584, 586, 1941. The waiver of immunity cannot be implied but must be unequivocally expressed. United States v. King, 395 U.S. 1, 4, 1969. The Tucker Act, the principal statute governing the jurisdiction of this court, waives sovereign immunity for claims against the United States that are founded upon the United States Constitution, a federal statute of regulation, or an express or implied contract with the United States. 28 U.S.C. 1491 A1. However, the Tucker Act is merely a jurisdictional statute and does not create any substantive right enforceable against the United States for money damages. United States versus Teston. 424 U.S. 392, 398, 1976. Instead, the substantive right must appear in another source of law, such as a money-mandating constitutional provision, statute, or regulation that has been violated, or an express or implied contract with the United States. Loveladies, Harbor, Inc. v. United States, 27 F. 3D, 1545, 1554, Fed Circ. 1994, and Bank. To determine whether it has jurisdiction, the court discerns the true nature of the claim in the complaint and is not constrained by the plaintiff's characterization of the claim. Katz v. Cisneros, 16 F. 3D, 1204, 1207, Fed Circ. 1994. If the court finds that it lacks jurisdiction over a claim, Rule 12H3 of the Rules of the United States Court of Federal Claims requires that the court dismiss the claim. B. Analysis. Plaintiff's claim, as best the court can discern, is premised on his interpretation of his status as a person who is alive and who may have been presumed dead, his contention that his birth certificate does not accurately reflect his existence, and his assertion that his estate, Marcel James Lamar Wood, registration number 1989-0051958, requires him to be compensated by the United States. These are sovereign citizen type arguments, where such plaintiffs attempt to convince courts that their status as sovereign citizens differs from the status of the fictional individuals identified by their birth certificates or their social security numbers, e.g., Davis versus United States, number 09-862C, 2010, WL 1685907, at 1-3 Fed CL April 22, 2010. Often, a sovereign citizen plaintiff will argue that his or her birth certificate and/or documents evidences a trust that he or she has the right to collect the funds in that trust from the United States. See, e.g., Davenport versus United States, number 17-1122C, 2017, WL 5988354, at 2 Fed CL December 4, 2017, stating that proponents of the sovereign citizen theory allege that their security interest results in the creation of an individual trust account and attempt to claim the funds in that account by suing the United States. Rivera versus United States, 105 Fed CL 644-646, 2012, noting that a sovereign citizen may assert that he or she is a sovereign, not a United States citizen, and therefore is entitled to obtain certain funds under a theory known as redemption. As in this suit, see, I'm not exactly sure, but COMPL App 1, maybe complaint application, but I'm not sure. A sovereign citizen may reference the House Joint Resolution 192 of 1933 as a legal basis for his or her redemption claim. Rivera, 105 Fed CL at 646. The sovereign citizen redemption theory typically includes the following elements. Many sovereign citizens believe that when the government began issuing legal tender in 1933, all citizens were pledged as collateral for the national debt, resulting from the loss of value from the gold standard. All sovereign citizens therefore have two identities, a real private individual and a fictional public person. Refusing to be used as collateral can hypothetically result in access to a trust fund held in the fictional person's name at the U.S. Treasury. Jessica K. Phillips, Not All Pro Se Litigants Are Created Equally, Examining the Need for New Pro Se Litigant Classifications Through the Lens of the Sovereign Citizen Movement, 29 GOJ, Legal Ethics 1221-1226, 2016, footnotes omitted. Sovereign citizens also sometimes reference the Sestake v. Act of 1666 or a Sestake v. Trust as support for their arguments in court. See United States v. Neeson, 555 F. Sup. 3D 1174-1182 DNM 2021, discussing a pro se criminal defendant's sovereign citizen arguments that relied on the Sestake v. Act of 1666 to assert that the court had no power over him. Amon v. United States, 142 Fed CL 210-216, discussing a sovereign citizen's redemption claim based on an alleged Sestake v. Trust account at the United States Treasury. Appeal dismissed. Number 19-1759, Fed Circ. June 21st, 2019. Here, similarly, plaintiff relies on the Sestake v. Act of 1666 in both the form complaint and its appendix to assert that because he has been presumed dead, the United States became the custodian of his estate and now owes him in the interest of the estate. Finally, the court notes that sovereign citizen plaintiffs often make a distinction between their names written in all capital letters and the same names written with just the initial letters capitalized. See Bryant v. Washington Mutual Bank, 524 F. Sup. 2D 753-758 N8, WDVA 2007, noting that the sovereign citizen theory typically asserts that the name of the fictitious entity is the real person's name in all capital letters, which apparently explains why names are commonly written in all capital letters on birth certificates, driver's license, and other government documents. I believe that's probably affidavit, but I'm not too sure. 282 F. Appendix 260, 4th Circuit, 2008. Sovereign citizens typically believe that when they use the proper capitalization of their names, they can redeem the funds held by the United States in secret individual trust accounts, one for each citizen. Here, too, plaintiff states that his proper name is not to be written in all capital letters as it was written on his birth certificate, and that he is entitled to the interest of the estate held by the United States. In short, the legal fiction presented by plaintiff in the complaint is not based in law but in the fantasies of the sovereign citizen movement. There is no jurisdiction in this court for fictitious claims. See Boeing v. United States, 968 F3D 1371-1383, Fed Circ. 2020, stating that allegations of subject matter jurisdiction, to suffice, must satisfy a relatively low standard, but also noting that essentially fictitious claims do not meet the standard, quoting Shapiro v. McManus, 577 U.S. 39, 45-46, 2015. Like other monetary claims of sovereign citizens this court has considered, plaintiff's claim must be dismissed for lack of jurisdiction. See e.g. Amon, 142 Fed CL at 220, dismissing sovereign citizen redemption claim sua sponte for lack of jurisdiction. Gravatt v. United States, 100 Fed CL 279-285-288, 2011, dismissing sua sponte sovereign citizen claim founded on fictitious trust fund account with the United States Department of the Treasury for lack of jurisdiction. 3. Conclusion. The clerk's office is directed to dismiss the complaint for lack of jurisdiction without prejudice. Furthermore, the court certifies pursuant to 28 U.S.C. 1915 A.3 that any appeal from this order would not be taken in good faith because, as alleged, plaintiff's claim is clearly beyond the jurisdiction of this court. No costs are awarded. The clerk is directed to enter judgment accordingly. It is so ordered. Now, what you just read was a very, very recent court proceeding in which this gentleman attempted to go into court and argue pretty much everything that is being taught inside of Christopher Hauser's group and amongst this redemption movement. This is all redemption theory, sovereign citizen, straw man nonsense. And the reason why I say it's nonsense is because as much as people like to talk, I have yet to find anybody anywhere that can show me a court case where somebody went into court, whether they had jurisdiction or not, and the court responded favorably to the information that the person was bringing into court. This being the case, I can't take this information seriously because the courts haven't taken it seriously. And as I keep saying, when all else fails, when you've sent as many 1099-As as you can send, when you've sent all your conditional acceptances, when you've gone and tried to put liens on public officials and on businesses and on CEOs and everybody else, and all of that stuff doesn't get you anywhere, the only other place that you have to go is court. And if it's not going to work in court, then what is the point? There are over 10,000 people within Christopher Hauser's group. If you all feel so strongly that you're being wronged by the United States government and that they owe you something, get together and put together a class action lawsuit and then sue the U.S. government. And let's see how far you get with that. But nobody does that. Nobody studies trust law and tries to figure out whether or not these trusts actually exist for their benefit and actually exist in the way that they say they exist, and they're able to access these trusts and do whatever they feel like doing. Nobody's been able to say that. Nobody's been able to show proof of that. So until you're able to show proof, we have to look at documents like this, whether the court lacks jurisdiction or not. Why? Because we have opinions from sitting judges who have gone in and actually listened to these cases, and their opinion is that the things that are being presented to the court are nonsense. They're delusions. They're fantasies of the sovereign citizen movement. And yes, I am now calling you all sovereign citizens, because at this point, there's far too much delusion going on within this movement for me not to just call you all what you are. I don't want to call you idiots. I don't want to call you retards. I'm going to just call you sovereign citizens. As much of a misnomer as it may be, you are now a sovereign citizen because you're stupid. So I'm going to be going and getting further court cases and reading those cases as well, so that way people can get an understanding of exactly what the court's opinion has been repeatedly over the past several decades. Because it just appears to me that people are not taking the court seriously when they dismiss these cases. And people are saying that, well, it's just a court opinion. It doesn't really mean anything. Well, yeah, I mean, you're absolutely right. It is the court's opinion. But to say that it doesn't mean anything, meanwhile you're not seeing any results, I mean, you're not making very much sense. So it's either one thing or another. It's, there's always some form of an excuse. At this point, we have the court's opinion, and although they do lack jurisdiction, they've given their opinion. They don't see anything in there that has any sort of truth or viability to it. And at this point, if you can't show me a court case that was presented in a court that does have jurisdiction where it has gone favorably, then I can't, in good faith, believe your argument or listen to anything you have to say. Anyways, that's it for this particular video. Take care.